All right, this case D 473360, Ruiz case. Parties are present. This is the time set for the 16.2 case management conference, as well as plaintiff to file a motion to establish custody, set support, etc., etc. First of all, in looking at your financial disclosure forms that you file with the court, you're still living together, correct?
Yes.
So why would I order any sort of support if in fact you're still residing together? Are you intending on leaving? Anybody intending on leaving?
Yes, I am, Your Honor.
When would that be?
With their approval, I was hoping to leave to California on the 16th of March.
With all 5 kids, that's probably not going to happen. First of all, was that even in your paperwork?
No, but me and him came to an agreement.
Oh, I'm sorry. If you have an agreement, that's different. I should have started with that. Have you come to an agreement
Yes,
regarding
we have.
that?
Yes.
All right. Do you have the terms? Because my preference is you're not going to let the kids finish out school, the school year?
That's the thing. Probably not. I was going to continue going to Cali.
Well, if you, here, again, you are these children's parents. Hopefully you guys are doing what's in their best interest, so why don't you let me know what the agreement you've reached.
Me and him agreed that I would have primary physical custody of the 5 children.
Okay.
We would be able to go from Nevada to California.
Okay.
If there is 48 hours and we go anywhere other states, we would let each other know an itinerary.
Okay.
The way my paperwork showed of how if it's more than 4 days on a long distance one, then he would have the children, I would have the children. Summer, holidays, every other holidays on even and odd. We agreed to that. The only thing we did not agree upon was the child support, the spousal, and if he would help me pay so much on the bills that me and him accumulated during our marriage.
Okay, let me let you know that we do this in 2 stages. First of all, we have to resolve custody first. If you've resolved custody, then we can move on to the second part, that being division of any debts, any claims for alimony, etc., etc. Okay? So, let's start with, you're agreeable that she had primary physical custody and the ability to relocate to the state of California. Is that correct?
Your Honor.
Okay. What part of California?
Southern, by LA, San Bernardino County.
I didn't get that city.
What city?
San Bernardino County.
And when are you leaving?
I would like to leave on the 16th. I have an interview that's signed up, ready to go. So if I could get the job, that would be great.
Are you okay with them leaving?
Yes, I do, Your Honor. That's
Okay, we'll go ahead and allow that. Here's the thing. Obviously, this is not like your first and only hearing. If you guys reach an agreement regarding alimony, that's something different. You know how much you're approximately going to be earning? Is it anywhere near what he earns?
I don't have anything right now. No earning, no income.
The job you're looking at.
Oh, it's $10 an hour.
You understand child support is set by statute? Have you calculated out what that would be?
Yes, but me and her has sat down and in agreement with money wise and for like the amount I'm able to live, so I can get my own place, and with the vehicles and the payments and stuff. We sat down and I gave her an amount. She agreed to it, and I think that's what we're gonna go with including the alimony.
How much?
$1,250 a month in payments of every Friday.
$1,250 every Friday?
No.
$1,250 total per month?
Yes.
Is that your agreement?
Yes.
Okay. I mean, All right, under the statutory formula, technically you would owe 1632. I have to have a reason for deviation with her relocating to the state of California. I will go ahead and deviate that downward to the 1250. I'm going to go ahead and designate that as just child support. Are you okay with that?
That's fine.
And I will deviate downward from the 1632 to the 1250 as agreed upon. And the reason I can, I guess, justify that is the fact that's going to include the fact that she's relocated to the state of California and any transportation costs that you have to see the kids. Does that make sense? So that's literally going to come out of your pocket to see them.
Right.
Okay.
Right.
Get your deviation factor, Madam Clerk. That deviation factor would be NRS 125B080 subsection 9I. So then what are we down to? Debts?
Yes.
I'll let you know the general rule. Typically, community debts are split evenly, and you're both held jointly responsible for them. Unless it's something, let's say, and it does happen, let's say, for instance, someone puts a credit card or buys a car on a credit card and is taking that car, then they will typically take that associated debt. Shy of that, if these were, say, credit cards incurred during the marriage, the presumption is they get split.
Right. The only thing, Your Honor, is that yes, we did. It was her credit. It's all her. I had filed bankruptcy 3 years ago, so I have no credit cards at all. We do have. So all the credit cards are actually hers. Yeah, at times they had cut my hours down to 40 hours. After I was working a lot of overtime, so they closed the yard, and I transferred here to the Cheyenne yard, and so we actually started using her credit cards to live, and I just feel that she committed more debt to the credit cards than more than they're not under my name.
Here's the thing, and I know it may not seem fair, and again, I'll be candid with you, we don't get into your feelings, how you feel about it. She's your wife. She incurred debt during the marriage. The law presumes if you weren't okay with that, and I know it's not reality, but the law presumes if you didn't like that, you would have filed for divorce immediately upon finding that and not let her incur that. Does that make sense?
I am helping her out, Your Honor. I'm taking the higher car payment.
I'm just the higher what
The
payment?
higher car payment.
Listen, all I'm saying is, if it can't get resolved, we've got to come back for a hearing on it. Do you understand that?
Understand.
You understand that too?
Yes.
So it's up to you guys if you don't. Otherwise, I also need specifics on holidays and stuff. I will allow you to participate telephonically from the state of California, meaning you don't have to come back to the state of Nevada since he's already given you permission. But I am going to give you a referral to the Mediation Center so you guys can go through specific holidays, things like that.
I actually have it in my paperwork, the specific holidays.
In your opposition,
Yes.
that again, because I didn't see in there that you anticipated even moving to California.
No, just like if I was, at the time I didn't know I was moving to California, but as I was here, we had the holidays, what weekends.
See, people living out of state have different type of schedules. Make sense? I mean, how is he ever going to see the kids?
Major holidays, the spring break, summer, Thanksgiving.
Do you know what those are?
Yes, it's every odd. I got the
All right.
odd evens. And she got
We'll go
the
ahead and I'll have you transpose into an order what those are going to be. I'll have you sign off on it, and you're fine with that. I will also put in the minutes that if things don't work out in the future, that you guys are to participate in mediation at the Family Mediation Center. Again, you won't need to appear physically. You can just do it telephonically from the state of California. Okay? So,
As far as the debt then, it's 50-50, correct? So
I am just letting you know that that is a presumption. I also don't know what assets you guys have. I'm assuming, I mean, you've been married a little bit of time, obviously living together a long time, I'm guessing. I don't know how you guys are dividing your stuff up. Usually, we don't like to get into pots and pans, so I'm assuming once you separate and move to California, you're going to take what's yours, he's going to keep what's his, and it's easier to just say, well, whatever they have in their possession. But you haven't left yet. So, why don't I set what we call one more status check date in about 60 days? If you guys can reach an agreement regarding, because I need specifics on the debt, the preferences, so we don't keep it, you're both jointly liable, because then we only come back on further contempt proceedings. How many credit cards is there, approximately?
I'm not sure. She.
I could actually give you the total amount of debt.
Are they listed in your?
Yes, they are.
See, the preference would be, I see them on page 6 of your financial disclosure form. The preference would be to divide those up evenly as possible, and then just say, I'm going to be responsible for these, and he's going to be responsible for these.
It wouldn't just be a total amount, and then because it would be 10
Now,
and 10.
You're going to be back if someone doesn't make a payment. It's just simpler,
Okay.
because then you can pay minimum payments for indefinitely as long as it doesn't affect him. He can do the same thing. Or if you choose to hurry and pay him off, then you're done. That'd be the preference. And then, as far as the cars, you're keeping your respective cars.
At the time, yes.
What are you keeping?
I'm keeping the Honda Pilot.
Okay, along with its associated debt.
It's my vehicle, and the vehicle that she's keeping, the Toyota, that's mine and hers.
How do you fit 5 kids in a Toyota Corolla?
Yeah, I have to get another car.
Oh, seriously, how do you get to California with 5 kids in a Toyota Corolla?
With the help of my mother, but I'm looking into getting another car, getting that one in.
Okay, all right. Are you're agreeable with that? You're keeping the Toyota Corolla along with the associated debt. He's keeping the Honda Pilot. All right. And then we'll be back, I guess, to find out what agreement. Again, you can appear telephonically for the return hearing. If assuming you're in California, it's just to see if you guys reached a final resolution. If so, we can prove it up on that day, and hopefully you guys can get divorced on that day. Okay? Make sense? All right. Listen, by your agreement, I'm going to take this agreement so you are not going to be able to change your mind in the next couple of days regarding primary physical custody, that being her have primary physical custody with the right to relocate the state of California pursuant to EDCR 7.50. You want to agree that this is a binding agreement, sir? You're not going to be able to change your mind?
No.
You as well, ma'am? I guess you more about the amount of child support. Okay. You understand that you probably not going to be able to petition for a change in child support unless he is going to make 20% more, or it's been 3 years. That's probably your next time you'd be able to review child support. Do you understand that? Okay. Miss anything, Madam Clerk? Oh, let's get whatever else we can. I'm assuming you have insurance on the kids?
Yes.
You know if that's going to be good in California?
Yes.
Okay. Any out-of-pocket expenses related to that, we will go ahead and incorporate the Family Court 30/30 rule. That's right. Never mind. I need you to prepare me the order from today, since you're apparently more familiar with the holidays and stuff, okay?
Okay.
All right. Hopefully you guys can come to an agreement about where you're going to meet with the kids. I don't know if you're going to meet halfway. I don't know if someone's going to do all that.
Halfway.
Okay, go ahead and put the, like bar store, wherever you're going to meet and stuff like that. So, digress. So you're 99.9% done. Just figure out the debts, and if you get that in decree format about how you're going to divide it, and then just simply put whatever assets you have in your possession are yours, whatever he has in his, you can submit it by summary disposition, and then no one will even have to come back to the return date.
Okay.
Does that make sense? Because the only thing holding us up is how you're going to divide the debts.
Can we? Can I just take a couple of her payments and just say the furniture? I think we're still paying furniture, right? I'll take the furniture off her hand, and she could pay everything else. Because I think the furniture will go, what, a couple thousand still?
Furniture is 4,000, and then the bed has 1,300 left on that one.
See, here. Do you have a copy of your financial disclosure form?
I think I do, yes.
Hers.
Of hers?
Hers.
Oh.
Marshall.
Yes, I do.
This thing. See that list of debts?
Right.
So somehow, some way, I have to allocate someone's going to be responsible for those. Where I specifically, I again, I don't know. And is does that make sense?
Yes, Your Honor. I have already, we already filed our taxes,
Okay.
and the only thing I asked for was for $1,500 for my son's braces, and she has the rest of the money. I think we got about $5,000 to start off, and she has the rest of the money to start making payments on these credit cards.
That doesn't until they get paid off.
Right. I'm saying so like that we could start, eliminating the debt.
All right. I'm trying to avoid coming back. So I'm not gonna. Why don't we just light it up? All right.
It's lit.
I mean, swear 'em in is what I meant.
Okay.
Let's just swear 'em in and do it.
All right. Would you both please stand and raise your right hand? You and each of you do solemnly swear that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Sir?
Yes.
Please sit. Thank you.
All right. Go ahead and have a seat. Sir, would you state your name for the record
My name is Eric Ruiz,
and your address?
317 Moonlight Glow Avenue, North Las Vegas, Nevada, 89032.
Are you a resident of the state of Nevada?
Yes, I am.
When did you come to make Nevada your home and residence?
May 2005.
You want to stipulate that he is a resident of the state of Nevada?
Yes.
Marshall Bill, you want to check a driver's license? You have a driver's license with you here today? All right.
Las Vegas issued June of last year.
I'm going to hope that they break it up specifically, so I'll put that on the record. Was that a yes? We're good?
Yes.
All right. All right, you and the defendant have 5 minor children, is that correct? However, apparently you were married subsequently on August 3rd, 2007. Is that correct?
Yes.
All right. Have you become incompatible in marriage in that your likes and dislikes have become so divergent you can no longer live in marital harmony? Is there any possibility of reconciliation at this time?
No.
You have come to an agreement whereby you are granting the defendant primary physical custody of the minor children and the authority to relocate to the state of California. Is that correct?
Yes, Your Honor.
I'm assuming you're going to have joint legal custody. Is that correct?
That's correct.
You are in agreement with her regarding a holiday schedule, summers and things like that, and she's going to craft the decree, put those out, and I'm going to have you sign off on it in agreement. Is that correct? And if you
Sure.
are unable to agree, then I'm going to refer you to the Mediation Center so that they can help you do that. Is that correct? Do you believe that's in your children's best interest?
I believe so, yes.
We have, as far as child support, you would pay a little over $1,600 under the statutory formula, but you have agreed between the two of you to make that $1,250, including the fact that you are going to have to make some travel arrangements to see the kids. Is that correct?
Yes, Your Honor.
You have health insurance for the minor children. Is that correct?
Yes, Your Honor.
And you're going to maintain that, and any out-of-pocket expenses related to that, you're going to split that with the defendant. Is that correct?
Yes, Your Honor.
As far as your assets, you are going to keep the Honda Pilot and the associated debt. The defendant will keep the Toyota Corolla and its associated debt. Is that correct?
Yes, Your Honor.
Additionally, the defendant has listed approximately $22,000 or so on page 6 of her financial disclosure form. You are going to remain jointly liable for that debt, but the court's preference is that you submit that where you each specifically remain liable for specific debts, correct?
Yes.
I can't force you to do that. If you want to keep it that way, then you can do it that way, correct? All right. The household items, you guys have reached an agreement of the stuff that she's going to take to California and the stuff that you're going to keep. Is that correct?
Yes, Your Honor.
Do you believe that to be fair and equitable?
Yes, Your Honor.
Apparently, as part of this agreement, she's also going to waive her claim for alimony. Is that correct?
Yes, Your Honor.
Did I miss anything else, Madam Clerk?
She's shaking her head.
No,
But-
I was going
but-
for spousal support.
Oh, I'm sorry. Then we'll have to come back for a hearing then, if you guys can't agree.
No,
I thought you'd agreed to $1,250, and that's
Yeah,
what I'm saying. I was
$1,250.
going to
Okay,
designate
yes,
that,
Yes. Sorry.
right?
Yes.
Let me let you know that actually to your benefit, because if you deem any part of that as alimony, then you actually get taxed on it.
Okay.
So it's to your benefit that it's deemed child support.
Yeah,
Make
yeah.
sense? All right. Other than that, am I missing anything? I'll ask her. The agreement that you've reached today regarding your kids, including the relocation to the state of California, do you believe that's in your kids' best interest?
Yes.
You've come to the agreement that he's going to pay you $1,250 in the amount of child support. Is that correct? The agreement regarding the assets and debts that we've set forth in the record, do you believe that's fair and equitable?
Yes.
And you've agreed as part of this full agreement to go ahead and waive alimony. Is that correct?
Yes.
Do you have any questions, clarifications? Are you wanting your maiden name restored, or you want to keep it as Ruiz?
That's Ruiz for the kids.
All right, I'm going to go ahead and have the defendant, since she's more knowledgeable about the holidays and stuff, be the one to prepare the decree of divorce. Hopefully you can do that before you leave, okay? Hopefully
Yes.
do it within the next few days. Submit that to the third floor. We'll go ahead and sign off on it. The matter having been submitted pursuant to the terms set forth here on the record, an absolute decree of divorce hereforth granted, the bonds of matrimony existing between the plaintiff and defendant hereby dissolved, and the parties are restored to the status of single, unmarried persons. So it's not finalized till you get the paperwork back, though. Other than that, you're done except for the decree. And then I need him to sign off on it as well so he understands the terms. Okay? All right, you guys have a good day.
Thank you, Your Honor.
All right.